Okay, so we'd like to thank everyone for joining us this afternoon. I'd like to introduce myself, Misha Yoklis, and my colleague and partner, Lauren Bilas. We are in the New York office of Chartwell Law, both specializing in workers' compensation. Chartwell Law, if you don't know, is a full-service law firm with 18 offices located in Florida, Maryland, Massachusetts, New Jersey, New York, Pennsylvania, and Rhode Island. And if you have any questions, you can write them in the Q&A section. We'll try to take as many questions as we can as we go along, and there will be a Q&A session then as well. So if we don't get to your question right away, then we will try to answer it to the best of our ability at the end of the presentation. And with that, I will turn it over to Lauren to commence our presentation.
Thank you, Misha. And when he was talking about a Q&A section, if you look down at the bottom of the Zoom screen, there is a button called Q&A, and you can enter questions there. I'm just going to share my screen. We have a PowerPoint presentation ready for y'all, and we will make this available after the presentation so that you all get a copy. It has clickable links with links to the materials that are referenced in the PowerPoint. So hope you find this educational. Hope you find it a little entertaining during your lunch hour. And we'll just hop right into it. So a lot's been going on in 2020, obviously. It's been a crazy year, but in addition to all the things that happened at the board with COVID, there were a lot of 2017 workers' compensation reforms that started to come into play this year. And we'll get to those. And there were also a couple notable third department decisions. So we'll discuss those all, and me and Misha will take turns. The first thing we're going to talk about is the system improvements that were part of the 2017 workers' compensation reforms and started to come into play this year. So as of January 1st, 2020, the board expanded the type of providers that can be authorized by the Workers' Compensation Board to treat injured workers as well as bill in their own names. Previously, licensed clinical social workers, acupuncturists, and nurse practitioners, physical therapists, occupational therapists, physician's assistants couldn't treat on their own without personal supervision of a authorized provider. Now PAs are the only ones that need to be supervised by an authorized physician. Now, while the board expanded the types of providers that can treat injured workers, they did not expand the types of providers that can perform IMEs. The purpose of this expanded provider law was basically to allow injured workers to treat with the same types of practitioners that people that aren't treating under workers' compensation system will treat with. So if you go to a doctor's office, a lot of times you're seen by a physician assistant instead of the actual doctor. That wouldn't have been allowed before without supervision of a authorized physician. So the board's just trying to modernize and bring workers' compensation treatment up to date with the way things work in the non-workers' compensation world. In addition to adding new types of providers, the board updated the medical fee schedules to allow for the billing, to provide for the types of billing that each of these different providers would do. Now, all of these different types of providers that are now authorized to treat under the workers' compensation law can't necessarily comment on all of the issues that are applicable in a workers' compensation claim. So for example, the physician's assistant can't provide an initial, actually, let's not go with the physician's assistant. Let's say a physical therapist can't provide the initial disability report to support awards. And a occupational therapist cannot comment on permanency. So you have to look out when you get a C43 to make sure it's from someone that is authorized to comment on the issue of permanency before getting an IME. I've had claimants attorneys after this expanded providers law came into effect, produce physician's assistant reports on permanency, and then we were able to object to the C43 without having to get an IME and give the claimant permanency report, a valid permanency report before they produce one on their own. Now, the prescription drug formulary is another thing that started coming into play more last year because new prescriptions, oh, I skipped one. Okay, I'll go back to that one. So the prescription drug formulary set forth a list of preferred medications that don't require pre-authorization. A doctor can prescribe them without pre-authorization. And it's based on studies into medication's effectiveness and appropriateness for treatment. Prior authorization is sought through this medical portal. And if a provider fails to seek prior authorization when it's required, you do not have to pay for the prescription bill. Out-of-state providers are required to comply with the drug formulary, despite the fact that they might not be familiar with the rules of New York workers' compensation. Now, treating physicians were required to seek pre-authorization for any non-formulary medications for new prescriptions effective December 5th, 2019. They were given a grace period to adjust their current prescriptions to the formulary until June 5th, 2020. But because of COVID, the board pushed off the date that refills or renewal prescriptions have to comply with the formulary to January 1st, 2021. Remains to be seen whether that date will get pushed off again as far as refills and renewals having to comply with the drug formulary. Depends, how COVID winter is, I assume, because if it kicks back up again, it's possible that the chair might extend it another 6 months or so. Remains to be seen. So I'm going to go back to the IME studies slide. One other thing that the 2017 reforms did is direct the board to conduct a study of IMEs in 2018. The board heavily regulates IMEs way more than it does in any other area of the law, like say third-party litigation does not have as many rules governing IMEs. Yet the board, despite all the regulations currently, still has concerns about how the IME process moves forward. Apparently only 2.5% of authorized IME providers perform 72% of all IMEs. So a lot of IMEs that are authorized by the board aren't being used, or if they are being used, they're being underutilized. It seems like people go back to the same doctors, which is what you see. So the board conducted a study on the utilization of IMEs, and then they sent that study to an IME advisory committee in 2019, who is to review the board's findings and make recommendations on how to improve the system. And the only thing, that committee was made up of people on both sides, carrier side, claimant side. And the only things that they were able to agree on recommending unanimously were that there should be flexible scheduling of IMEs. For example, if the claimant gets the notice, you typically pick the time and date, and then the claimant will say whether they can, if they can't make it, they'll let you know. But they recommended allowing for the claimant to schedule the IME with the provider at a time that works for them. The other recommendation of the IME advisory committee was to provide for continuing education for the IMEs. So nothing major was proposed, and it remains to be seen whether the board will actually implement any changes as a result of that advisory committee's recommendations. But it's just something to be aware of, because this was something that was supposed to be addressed this year, but it's obviously been put on the back burner, consideration of changes to the IME process in light of the fact that there's so much else going on this year.
Lauren, we have a formulary question. How do you
Sure.
avoid the directing care issue when providers aren't submitting medications through the formulary, but you need to advise them to submit via the portal?
So what was the first part of that question?
How do you avoid the directing care issue when providers aren't submitting medications through the formulary, but you need to advise them to submit via the portal?
If they're not seeking pre-authorization, I mean, then you would just deny the bill. It wouldn't prevent them from filling the prescription unless I'm not aware of something. And obviously it'd be better if I could go back and forth and clarify the question. So the portal just has to do with seeking pre-authorization for prescriptions and payment issues. So it's not, I don't see a direct care issue in that we're not telling them what to prescribe. It would just be, we'd be able to deny payment if they're not going through the portal. And if the doctor wants to be paid, I would hope that he'd eventually learn how to seek pre-authorization. I don't know if that answers the question. So if anything, follow up with me after the presentation. Was there anything else right now?
No, that's all we have. Thank you.
Okay. All right, prescription drug formulary. It was anticipated that the prescription drug formulary, once fully implemented and the doctors have to act in accordance with the formulary for refills and renewals, that it will limit medical exposure going forward. We have a lot of prescriptions that are very expensive that wouldn't be considered formulary medications. The formulary allows for generics to be used. So hopefully once the January comes and the refills and renewals have to comply with the drug formulary, it will result in cost savings to payers, especially for opioids, because it's very hard to get a opioid prescription under the drug formulary. The drug formulary only allows for single dispensing of a 7-day supply within phase A of the formulary or during a perioperative period. Again, it's a 7-day supply, and only the short-acting formulation can be prescribed. And for long-term opioids, the provider would have to seek pre-authorization, and then it's not easy to meet the burden for pre-authorization under the guidelines. The only thing is that there are very short timelines for responding to requests for pre-authorization. So I'm seeing a lot of payers not timely responding, and then the board will authorize the requested medication a certain amount, maybe not the full amount requested, but it is important to stay on top of the pre-authorization requests in order to feel the cost-saving benefit of the drug formulary. Okay. Now, another thing that's starting to come into play this year is the 2017 reform legislation's cap on temporary disability benefits. So the reform legislation provides a credit against the PPD caps for periods of temporary partial disability after the 130th week from the date of injury. So there's been some discussion among defense counsel about people recommending or reading this different ways, but our reading of this amendment of 15.3W is that once we've reached the 130 weeks post-accident, the carrier will have a credit against the caps for any periods of temporary partial disability benefits, not temporary total disability benefits, only temporary partial disability benefits. And typically you're only seeing TTD benefits that long after the accident if there's something like a surgery or exacerbation. And there was a third department case this year, matter of Sanchez versus Jacoby, which we'll talk about later. But that confirmed that post-classification periods of temporary total disability don't count against the caps. So now, as far as of like October 2019, this started coming into play for cases that haven't been settled within the 2.5-year mark, as far as doing settlement evaluations. We should be taking into account the potential credit for any TPD benefits that were awarded after the 130th week mark. We anticipate that this issue of the credit against the caps will be addressed at the time of classification. I think that we haven't actually had it seen it happen in practice yet. We just hadn't had a case. I think most of ours just settled before the 2.5-year mark, or yeah, I mean, that's my only explanation for it, that it hasn't come up yet. But it doesn't seem like it's coming up with many other defense counsel either, because the board was supposed to issue further guidance on this, and it hasn't yet. So I assume if it's been addressed a lot at the board, that the guidance the board is supposed to issue on the safety valve, which I'm going to get to on the next slide, they would have issued by now, which they haven't. So it's something to keep in mind for any cases with a date of accident after April 10th, 2017, where we are more than 2.5 years post-accident. So there is
a question about the safety valve. Do reduced earnings count as TPD benefits toward the safety valve?
Temporary partial. Yes, they should. It should be anything but TT and TR, because if you have reduced earnings, that means you have a partial disability. And yeah, so those reduced earnings weeks would count against the cap. One thing is that since TT benefits wouldn't count against the cap, you can't settle on a TR rate after the 130-week mark, because then a TR rate wouldn't count against the caps. But I'm going to get to this in the next slide. You can settle on a TR rate, but then you'd have to eventually litigate those TR rates in order to determine the cap weeks, because when you're settling on a TR rate, there's a dispute. Claimant has a total rate and we have a partial rate. So then those weeks would still be disputed at some point as far as whether they would count against the caps. So you'd have to make a decision either to litigate those weeks as you're accruing them, or to just litigate them at the time of classification, to go back and litigate any TR rates after that 130-week mark. And this doesn't happen too often where there's a claim that old and there's still a dispute on TT versus a partial, and it hasn't been litigated earlier. Okay, so the safety valve is a way out of this 130-week cap on TPD benefits for claimants. Obviously, with any other way to get out of the caps starting in maximum medical improvement findings, we do expect them to try to exploit it. And it basically extends the period of temporary disability beyond 130 weeks when the board determines that claimant hasn't reached MMI by that point. The way I'm reading it is that there's going to be a presumption of sorts that the claimant's at MMI at that 130-week mark, and then the claimant can show evidence that he's not. And if the board agrees, then the caps won't start until the claimant is actually deemed to be at MMI. And so if the safety valve is found to apply to the claimant, maybe had a surgery around the 130-week mark, so he's found not to be at MMI at that 130-week mark, then the carrier will have a credit for any weeks of temporary total, temporary partial, or TR benefits paid after the claimant is eventually found to be at MMI. Now that would only happen in a very few instances where maybe MMI is litigated prior to the issue of LWAC, or the judge finds no MMI and that finding is reversed on appeal. So then in that case, say the judge found no MMI and we appeal and the board panel finds that we were right and the claimant was at MMI. In that instance, then all those weeks after the MMI finding would be a credit against caps, even though the claimant wasn't formally classified, because typically the caps don't start until the board makes an LWEC finding. So that's one good thing, that even if the safety valve applies, we'll have a credit for any temporary disability benefits, whether TT or TP, after a finding of MMI. Again, yeah, the board issued a subject number in April 2017 saying it would issue further guidance on that safety valve in the near future, and it hasn't yet. So we do still expect that to be addressed at some point. Okay. I already mentioned that this 130-week issue may require us to litigate TR rates. It might change the incentives of us as far as whether we need to push for a finding of MMI to start the cap, when the caps will start automatically without us having to do so at the 130-week mark. It could incentivize claimants to settle at the 130-week mark because the caps will start running. So keep it in mind for any claims, again, with the date of accident disablement after April 2017. That are still outstanding 2.5 years post-accident, that this is something to keep in mind, as well as approach claimant about settlement, because any TPD benefits after the 130-week mark will start running their caps. Okay, another thing to keep that's happening in 2020, the payer compliance project is entering phase 2. I'm sure you've all gotten penalties for untimely filing of FROIs. Now the board is going to add a new measurement for the timeliness of SROI S1s, SJs, any SROIs for suspension of benefits. Generally, those are due within 16 days of stopping indemnity benefits. And if they're not timely filed, at this point, the board is just going to be monitoring the timeliness, send you guys reports as far as what the penalties would be had they been assessing them now. They'll start issuing penalties for non-compliance with the SROI suspension forms around April 2021. So file those SROI suspension forms timely upon suspending indemnity benefits. Okay. Another update this year is the CMS 1500 initiative. The board's getting rid of all those C4 forms and it's adopting a universal CMS 1500, which is used outside of workers' comp. So they're adopting that form. It's part of the expanded provider law, basically making it easier for these new providers to bill for their treatment. There were so many forms, it was confusing. They're trying to simplify medical billing. So we're currently in phase 1 of the CMS 1500 initiative, voluntary submission. Providers may use the CMS 1500s now. They are required to attach a medical narrative report to the CMS 1500 that has to comment on claimant's work status, causal relationship of the injury, temporary impairment, and if that medical narrative is not attached, eventually the provider won't be able to even submit the CMS 1500 without the medical narrative once we get to the electronic submission portion in phase 3. So at this point, providers can start using the CMS 1500. I'm seeing it already in eCase, and payers are required to accept those electronically at this point. You're required to acknowledge receipt when you accept them, and haven't heard any issues with that process so far. Phase 2 is going to start in around July 2021 of the CMS 1500 initiative. At that point, In order to object to payment of medical bills, you're going to have to electronically submit explanation of benefit forms with these new CARC codes. There's a link to those codes here, and you're still going to have to file the C8-1 and C8-4 forms at this point. The board is thinking about eventually eliminating those forms. Hopefully it does, because this is a lot to do just to deny a bill. But around July of 2021, in order to deny bills, you're going to have to issue both the explanation of benefit forms with the CARC codes as well as the C8-1s. And then there's going to be a way, upon receipt of an EOB form from you, the providers can submit HP1s electronically, attaching what they receive from you. And then later in 2021, providers are going to be required. Excuse me, did I hear something? No? Okay. Maybe it was feedback. Later in 2021, providers are going to be required to submit the CMS 1500s electronically in order to submit bills. There's a hardship exemption if they can't set up their offices to do so. But the board's going paperless to a large extent, which is good news. And we'll get to later additional things that it's doing to go paperless. There's new medical treatment guidelines coming out in January of 1st, 2021, ankle, foot, elbow, hip, groin, hand, wrist, forearm that are replacing the CTS guidelines, occupational interstitial lung disease, occupational asthma. And then I think it was just like this morning or maybe sometime this week, the board issued proposed guidelines for major depressive disorder and PTSD and acute stress disorder. Those would also go into effect on January 1st, 2021. And I'm excited about that because you see a lot of these psych doctors overtreating. And if we're able to use guidelines like we are with other sites to limit that psych treatment, that would be great. So I haven't had a chance to look through those yet to see, but I'm sure they're like the other guidelines where they have diagnosis criteria as well as treatment recommendations. And hopefully in 2021, we'll be able to better manage psych treatment because it can be an issue when it's such a subjective thing. So that's exciting. Okay. The last thing, the last part of this section is that the board is just announced like this OnBoard system. So it's going to be replacing eCase and all the other platforms currently used with this OnBoard system, which is going to be web-based. It's going to be accessible 24/7, so it's not going to go down constantly like eCase does with us. It's going to have, you're going to be able to file things directly with the board and have it served on all the other parties through the website. I'm excited for it. It's not going to be fully launched till 2023. So, you know, it's going to take a while for the board to figure this out, but it will be released in stages. Starting in spring of 2021, prior authorization requests are going to be processed through there. So prior authorization requests are going to be replacing the MG2s, C4 auths. It's all going to be done through this OnBoard system, and providers are also going to be able to file HP1s through that OnBoard system. All right, so now we're going to go into the COVID stuff. A lot of states have had presumptions enacted, and we've been looking out for New York and what's going on as far as whether there's going to be presumption of causal relationship for workers, any workers that contract COVID in the course of employment. New York is behind the ball on this, and probably for good reason, because there hasn't been much data. There's so much more unknown about COVID at this point and its lasting impact. A lot of states rushed to enact presumptions because it looks good politically. New York, there were some legislators that tried to do so around March during the budget legislation process, but since then there hasn't been any action on COVID presumption legislation. This page discusses some proposed bills, but there's no action on them that I'm seeing at this point. There's no presumption legislation like going to be signed tomorrow. The only thing that passed so far was a bill that established death benefits for beneficiaries of public employees who contracted COVID and died. So no, there's some proposed bills to establish a presumption of compensability for all essential workers. That is one of the ones that they tried to push through in March, but it didn't go through because the NYCIRB did a legislative analysis at that point back in March when everything was so crazy and estimated that the potential cost of a broad proposal to create a presumption that exposure to COVID is compensable occupational disease could exceed $31 billion. So that number scared legislators for good reasons. They didn't want to put a burden on the system and employers who are already suffering during this time. So that proposal for a broad presumption of causal relationship as an occupational disease did not pass. And again, there hasn't been any serious action on COVID presumption legislation since then. We are monitoring. We will keep you posted if we hear anything. I think it's going to be something that's addressed next year, or how the 9/11 stuff took many years to see the lasting effects, and then something was finally enacted. But New York isn't rushing to get these COVID claims established. There might be claims that are litigated now that are disallowed that might come up back on calendar later once the legislature does enact some sort of presumption if it's retroactive. And one thing to keep in mind is that the basis for these presumption bills to presume that COVID is related to employment is the thought that if someone's an essential worker and they're out working, they have a higher likelihood of contracting COVID than someone sitting home, or a hospital worker has a higher likelihood of catching COVID as a result of their employment. But one thing that's been interesting, and I've been monitoring some studies, is that antibody testing has shown that healthcare workers have either the same or lower positive testing for antibodies than the general population in the areas where they work. So the fact that it seems that the fact that healthcare workers have PPE is stuff that actually works, and it's protecting them at work because they're not testing any higher for antibodies than the general population in the areas where they work. So that's something that the legislature should keep in mind in enacting a presumption, because it's better to enact laws based on data than feelings. All right, I think Misha, you're taking over at this point.
I believe so. Thank you, Lauren.
Okay.
Okay, so what has the board been doing about COVID? Fortunately, we've had virtual hearings since 2018, so there was minimal disruption once the pandemic hit. Virtual hearings prior to the pandemic were optional, but of course they became mandatory once the pandemic was here. And there have been many other effects as well with respect to workers' compensation claims. So normally, claimants have to produce up-to-date medical evidence of a disability every 90 days. the workers' compensation law judge does have discretion to excuse it, but typically they did not in the past. Whereas in the post-COVID world, they have been excusing claimants' failure to produce medical evidence because of difficulties in getting reports from doctors. Now, one thing that makes things easier to get reports from doctors is telemedicine. So the board has authorized telehealth visits for the purpose of maintaining social distancing, obviously. And we've actually used our advantage in arguing that claimants may not be able to physically go to a doctor every 90 days, but they should be able to have a televisit done. Judges have still been quite lenient with claimants and have excused their failure to produce up-to-date medical evidence, but this has been sort of going back and forth a bit. Also, the claimants have gotten away with not attending IMEs as much as before. So in the past, we could have gotten their benefit suspended if they failed to attend an IME. Again, the judge could have excused it, but oftentimes they did not. Whereas now it's pretty much routinely excused because for whatever reason, claimants say they can't go there. Now that IMEs are becoming more common and easier to set up and easier to attend, and things are kind of opening back up, this is becoming less of an issue. But the judges would not have suspended benefits before, and even still today, we haven't really had findings like that. The board has recommended that in response to treatment requests filed on MG2s and C4 auths, that records reviews are utilized as much as possible without the need for an IME examination. And likewise, the board has been granting extensions, although with less frequency now that IMEs are back up and running, but especially initially, we were getting a long time to get IMEs, and if we needed an extension, that would be typically granted. The same goes as well for depositions, because doctors need to be at their offices in order to do depositions typically, so we were routinely getting deposition extensions, and again, that's sort of dying down. As far as pay compliant goes, the board has been a bit lenient in terms of late payments for initial payments, for instance. They had waived some fees, so that's something the board has also taken into consideration. Now,
yeah, it's
probably
to keep things in mind, just because in case things do get worse again for the winter and we can't set up IMEs again. That's why we're going over this again. These procedures could rile back up if the pandemic starts getting out of control again come winter time.
there is a question about virtual IMEs. The board has not yet authorized them. We do not know if they will. They typically require physical examination, but we have had some success getting peer review doctors to comment on degree of disability based on your records and having the awards reduced that way. I should note also that telemedicine is only allowed in circumstances, for example, prescription refills or cognitive disability. Something like a permanent evaluation would still obviously require a physical examination. So it's not like the board has allowed claimants to do absolutely everything virtually. But for the time being, IMEs still cannot be conducted based on virtual visits, and we are not really anticipating that to change unless Lauren has heard otherwise.
No, I mean, the only thing I could see it being useful for is maybe a psychological exam where you don't need to actually physically examine the claimant. But the board's trying to help the claimants here by allowing telemedicine. They're not trying to look out for carriers at this point.
So probably our least favorite effect of the COVID pandemic is that the board has suspended the requirement for labor market attachment for partially disabled claimants. And this is in effect so long as the state of emergency declared by the governor is in effect. Initially, that was supposed to expire in September. That has been renewed. It is currently in effect through November 3rd. We're expecting it to probably get renewed again. So we don't anticipate that labor market attachment will come into play anytime soon. Also, the board has extended the deadline by which providers must obtain prior authorization for refills or renewals of non-formulary medications to January 1st, 2021. It was previously June 5th, 2020. Now, MG2s and C4 auths are now expected to be submitted by email rather than by fax. So that's the prior authorization request we're referring to the next bullet. And also there are updated instructions for submitting CDM-Bs. If the medical is already in the file, you don't have to attach it. Even if it's not in the file, you can submit it separately from the CF1B because it's hard to attach documents while working remotely. And this is all based on the board's understanding that carrier adjusters will probably have to work remotely for at least a short term. Additionally, there are new codes that you can now put on your Freud's and Stroy forms regarding the nature and cause of injury. COVID-19 pandemic, there's now a new code 83 that can be used as a nature of injury code and the cause of injury code. You see that there are a couple of questions.
Check those out.
A copy of the slide deck can be requested after the presentation. We will be sending out a video of the presentation, a link to a video, but I think if you want an actual presentation, you might have to email us individually. Be happy to provide it to you. I'm not sure if our marketing department is going to be sending that to.
Yeah, we're going to try and send everyone a copy of the PowerPoint, but if you want it right away, just email either me or Misha, and we're happy to send you a copy of the PowerPoint.
There's also a question whether labor market attachment should be addressed formally anyway. I assume that's asking whether it should be raised at a hearing. We are still raising it at hearings, and we are requesting that they be directed to produce evidence of labor market attachment. Judges are not directing it, they're holding it abeyance. In certain extreme situations, it may be worthwhile to appeal something like that, but in most cases, it's probably not worth the additional costs. As soon as labor market attachment goes back into effect, we can file an RFA 2. We've raised it previously, and sometimes we can even get the judge to direct the claimant to produce labor market attachment evidence as soon as the moratorium on that is lifted.
Yeah, we understand that it's frustrating. I mean, we don't know how long this state of emergency is going on. And it doesn't seem right that the board would be able to suspend the labor market attachment this long. Businesses are going back, opening up again. They've certainly opened up a lot since March. So we did identify actually a case this week that we think we're going to appeal to the third department to try and challenge this board policy. So I would, tell you guys to look out for the right case to do it, where the claimant was deemed temporarily partially disabled after March, or when the state of emergency started, and you haven't been able to pursue labor market attachment for almost a year. We're making arguments about the board's authority to suspend the requirement based on its the fact that attachment is the way to prove that your wages are causally related. So the argument is that if you can't find a job because of the pandemic and public health crisis, that's not something that should be compensated continuously through comp, because your wage loss isn't due to your disability, it's due to the pandemic. So if you want to discuss that further with me, or you have a case you're thinking about taking up, I'm happy to discuss that further, because I find that issue really interesting, and we are trying to challenge the board on that.
A more recent response is there's been a letter of the chair that's been sent out on September 10th, 2020. And that's a letter from our chairperson, Clarissa Rodriguez, basically asking carriers to help gather and submit medical evidence in COVID-19 claims to help expedite their resolution, since a pre-hearing conference cannot be scheduled without medical having been submitted in these denied claims. Now, this letter reflects the reality that many of these claims are simply not being pursued and are probably being filed just because it's being reported to the employer that an employee potentially was exposed to COVID or has COVID, and then they're submitting paperwork with their carriers who are opening claims. But oftentimes, these claimants are not retaining counsel. There's minimal or no treatment, and the medicals are not being submitted. So these claims get opened up, and then nothing really happens with them. So, in the interest of moving things along, the board sent out this letter from the chair, which is a follow-up to a letter that was sent on April 15th earlier this year, where the chairperson basically encouraged carriers to work with their insured to make sure that COVID-19 claims are filed and processed quickly. And at that time, the board encouraged carriers to accept them without prejudice under Section 21A, rather than disputing these claims, to ensure that workers receive uh, their treatments, whatever they may need, on a timely basis. There's a question of okay, are we asking claimants to confirm that they're not collecting unemployment insurance and have not done so since their accidents? Is that enough to cut them off?
So that's something that we should be asking if they stop working. They were working and then they stopped working sometime after this pandemic. Like a lot of people are seeking causally related disability benefits despite the fact that they stopped working due to COVID. So that's something that I would always ask the claimant if they stopped working at any point right now, why they stopped working, why they are, and are they receiving unemployment benefits? But their receipt of unemployment benefits is not decisive of the issue. You can receive unemployment benefits and be partially disabled in comp. The amount of the unemployment benefit would be affected by comp, but comp wouldn't be affected by the unemployment benefit. It's just that if the claimant is on unemployment, it might support an argument of like that they didn't stop working for causally related reasons, or that they're not totally disabled if that's what their doctor's reporting.
It's also worth mentioning on the previous slide, there was a bullet about the medical director's office, which is part of the board, but usually works behind the scenes. They put out a bulletin on June 26th of this year regarding the COVID pandemic, and it was basically a summary of current knowledge, assessment and treatment of COVID-19. Basically, they said there's not a lot that was known about it at that time. The bulletin also provided some guidance for medical providers to comment cause relationship. This was obviously a significant event because the medical director's office does not put out bulletins very often. The last one was all the way back in January 2012. So they provided some guidance at the time, but there's been more recent developments on that issue regarding causal relationship of these COVID claims. So we'll discuss that shortly. So in terms of prima facie medical evidence of COVID-19, what is sufficient is a report of a positive test or a clinical diagnosis of the disease, or as we discovered recently in a case I'm going to discuss, a death certificate listing COVID-19 as the cause of death. Now, one important issue is whether these claims should be considered as accidents or occupational diseases. And almost always, they really should be accidental injuries, with the possible exception of healthcare workers. And the reason for that is that occupational disease requires a recognizable link between the alleged condition and a distinctive feature of the employment. It has to be from something that's ordinary and generally recognized risk in a given profession, which COVID-19 would not be, except for perhaps for healthcare workers. So for the time being, we're seeing that these claims are mostly being filed as accidental injuries, and that's the way it should be. But as I'll discuss a little bit later on, there was a case recently that maybe will give the claimants bar some ammo to try to get these claims pushed through as occupational disease claims. Now, as far as causal relationship, goes, unless there was a known specific exposure, it's quite difficult for claimants to demonstrate that the contraction occurred in the course of employment. And the challenge is there's no way to identify the time, location, and mode of infection, unlike in most accident claims. So in that sense, it is difficult. But there are ways for claimants, obviously, to have PFME and to establish causal relationship. So we're going to continue discussing this for the next few minutes. As far as IMEs go, it's difficult to say how helpful they are because nobody can tell you where you got COVID if you have it. So we can potentially just cross-examine the treating physician when the claimant produces PFME of the disease. But there could be a benefit to an IME stating something about a health study, especially in a given geography or a given profession. So it should be evaluated on a case-by-case basis whether or not an IME is worthwhile. Now, in the past, infectious diseases were treated in the following way. So they were typically disallowed where claimants failed to establish exposure to disease in the course of employment, and the cause of the disease was common in the community, such that the exposure could have occurred anywhere. In those type of cases, the medical opinions giving causal relationship were speculative in nature. By contrast, where claimants showed that they came into direct or close physical contact with infected individuals or their bodily fluids, the disease was endemic in the claimant's workplace, and or there was medical evidence consistent between the incubation period, the alleged date of exposure, and the onset of symptoms. When those factors were present in some combination, not necessarily all of them, infectious disease cases were typically established. So obviously it's critical to investigate claims as promptly as possible, take written statements from the employer, witnesses about any actual exposures, about the prevalence of the disease in the workplace, and also to look at data about the prevalence of disease, not only in the workplace, but in the surrounding area, and also where the claimant resides, because that could be an indication that they got the disease somewhere near their home and not in the workplace. So that could be a way to rebut the PFME. Back in June 2020, the Workers' Compensation Board put out a question and answer publication in which they discussed what kind of claims we can expect to be established and basically how to demonstrate causal relationship. So if someone worked in an environment where exposure risks are significantly higher, such as someone who works for the public, that's a sort of claim that we could see getting established. Of course, that includes healthcare workers and transportation workers. Alternatively, someone who directly interacts with the public, such as retail worker, they also probably have a higher propensity or more likely to be exposed in the workplace to COVID-19. So that's the sort of claim that would be established. But to demonstrate causal relationship, you do have to show that there's significantly elevated risk in the workplace, and a medical report is needed stating that your work caused your illness. So as the board said back then, a positive result test is best, but a medical report from an authorized provider showing a diagnosis via PCR test or by virtue of examination by a treating physician may also be used. Now, recently there was a case that came out, which was a board panel decision, so it's a relatively low appeal decision. One of the board panel judges was the chair of the board herself, Clarissa Rodriguez, and it looks like the board took this case an opportunity to lay out a framework for COVID-19 claims. In this case, a mechanic working at an airport got COVID-19, and he actually died from it, unfortunately. And there were no medicals submitted. All that was submitted was a death certificate listing COVID-19 as a cause of death. The judge found PFME, the carrier appealed. The board found this appeal was interlocutory because it was only founding a PFME. The case had not yet been established. But nevertheless, the board took this opportunity to confirm that a death certificate is sufficient to have a finding of PFME and move the claim forward. And then the board panel went to discussing the need for prevalence in establishing workers' compensation claims involving COVID-19. So they define prevalence as evidence of significantly elevated hazards of environmental exposure that are endemic to or are in a workplace which demonstrates that the level of exposure is extraordinary. And they said that a claimant may demonstrate prevalence through evidence of the nature and extent of work activities, which must include significant contact with the public and or coworkers in an area where COVID-19 is prevalent. So the board panel also discussed there has to be an elevated risk. Now, we reviewed the decision. We're reading this as saying that work exposure has to be greater than in the general public, but the board may interpret this as saying that significant contact with the public is sufficient to show that the disease arose out of and in the course of employment. So it remains to be seen how this case will be interpreted, and we do expect this to get appealed further because maybe not in this particular case, but in this principle to be appealed in other cases, because the board also said here that the doctor who's providing PFME needs to comment on the prevalence of COVID-19 in the community, but not only in the community, but also in the workplace. And how is a doctor supposed to know something like that? Just based on what the claimant tells them? It seems like that would not entail a medical opinion, but rather a factual assertion by the claimant, which can be disputed, and the doctor would have no way of verifying. Also, how prevalent is prevalent? What rate of infection would be enough for a case like this to get established? Now, prevalence, as we mentioned earlier, is only one factor in establishing infectious disease claims. But here the board seems to be suggesting that it is the primary, if not sole factor, and we don't agree with that. It seems like the board is making the standard of proof set lower than in past infectious disease cases, and that's why we think that there are likely appeals that will be forthcoming as a result of this decision. Okay, mental stress claims. Now, COVID-19 obviously is causing people to become quite ill, but even those who are not getting ill from it can potentially file mental stress claims. And a mental stress claim is something that's a psychological or nervous injury caused by identifiable trauma or prolonged unusual circumstances. And so one client asked us about a scenario where a reporter was reporting at a hospital with lots of very ill patients and many of them who were dying. And this reporter filed a mental stress claim. Now, it would seem like something like that would be compensable, but we do not recommend accepting cases like that from the onset, from the outset, because you don't know what kind of mental health issues this reporter had before, or any claimant that files a mental stress claim. They could be actively treating for anxiety and depression before this alleged exposure. So it's worth to deny these kinds of claims and develop the record on any pre-existing mental health conditions and get an IME on causal relationship as well. Now, as mentioned, in order to constitute a viable claim, the stress must be greater than that which usually occurs in the normal work environment, with the exception of first responders. For them, the level of stress does not have to be greater. It could be a normal level of stress because they deal with elevated stress as it is. And the types of claims that we could potentially see, or that we are seeing from COVID-19 related to mental stress, are stress due to a known exposure in the workplace, which we believe is most likely to get established. You can also have a claim due to concerns over potential exposure in the workplace that proves unfounded. Stress due to heightened risk of exposure attended to working outside of the home. So somebody might get very stressed out by just having to go outside and not sit home if they have a pre-existing condition and file a mental stress claim based on that. And then there are false alarm claims, which is basically if someone has contact with someone who was exposed, not even infected, and they could potentially file a claim. But we believe these claims are less likely to be established because that stress in the workplace is essentially equivalent to stress to potential exposure outside the workplace. Just by going outside the home, you're potentially exposed to COVID-19. So unless someone's actually infected at work, why should your level of stress be any greater by being at work than being anywhere else outside the home? But another potential scenario where a mental stress claim can be filed is if an employer is not following protocols and taking protective measures regarding employee exposure and response to reports of COVID-19 in the workplace. So to avoid claims like this, we certainly recommend that employers comply with government guidance regarding protective measures and also have in place and follow closely policies and procedures for employee reporting of symptoms, identification and isolation of potential infectious employees, notification of potentially exposed employees, and sterilization of workplace areas.
I just want to note that we know it's past 1 now. If you have to go, we're gonna continue on, but obviously if you have to get off, thank you for joining us, and feel free to contact us with any follow-up questions, or if you want a copy of the presentation.
The presentation will probably be another 10-15 minutes, just updating you all on some recent case law that we think will be very impactful on our industry. So if you're able to stick around, great. If not, you can listen to the rest of the presentation later on, because as we mentioned earlier, the link will be sent out to you. So the last thing I want to mention about COVID is now that people are working from home, there's the potential for an increase in work from home claims, somebody getting injured at home while they're working in their offices, home offices, in their bedrooms, in their living rooms, wherever it may be. So there was a case that the board decided about a year before the COVID outbreak. So it's important to make that distinction. This was a full board decision and actually involved a claim adjuster who was working from home, ironically enough. While moving and installing home office furniture during a lunch break, he got injured. And interestingly enough, the employer here had provided a computer, 2 monitors, and a keyboard, but did not provide the office furniture and did not agree to reimburse those items. So on his own volition, the claim adjuster purchased this new office furniture and was installing it on his lunch break and got hurt doing so. Filed the claim. The claim was denied, and the full board disallowed the claim. They said because the claimant's injury occurred while he was moving furniture, rather than performing his duties as a claim adjuster, and the employer did not pay for the furniture or direct claimant to obtain it, the record supports a finding that the activities that the claimant was engaged in were not sufficiently work-related to render his injuries compensable, and thus this claim was disallowed. The board was relying on a couple of past third department decisions in rendering this ruling. The first decision worth mentioning is matter of McRae versus Egan Real Estate, which is a 1991 decision. And that there, the third department said that employees who work from home outside direct physical control of their employers are potentially able to alternate between work-related and personal activities when they choose. For this reason, injuries sustained by employees working from home should only be found compensable when 2 criteria are met. First, when they occur during the employee's regular work hours, and 2, while the employee is actually performing her employment duties. So putting furniture together obviously was not this claims adjuster employment duty. And so, especially because he was doing it on his lunch break, the matter of matrix absence management was decided against him. There's also a second case worth mentioning from 2008, Matter McFarland versus Lindy's Taxi, another third-party decision, which said that injuries which occur while claimant is not actively performing his or her work duties, such as taking a short break, getting something to eat, exercising, using the bathroom, for example, should be found to have arisen from purely personal activities that are outside the scope of employment and therefore not compensable. Now, it's worth noting that the momentary deviation doctrine is obviously not applicable to work from home accidents. Other than exercising, which would not be momentary deviation even at the office, something like a short break, getting something to eat, using the bathroom would be compensable if someone were to get injured while engaging in these activities at the office. However, at home, apparently not. So the board has constricted, and so has a third department, what is compensable in the home setting. And that is to be distinguished from business travel, where there's an expanded theory of compensability that doesn't require one to be engaged in the duties of employment, just has to be that that the activities engaged in are reasonable. So if you go on a business trip, slip in the shower and fall and get hurt, that would be compensable on a business trip because it's a reasonable activity. Something like that at home obviously would not be. And if you went to the gym in your lunch break at the office and took a shower then, that would also be compensable. So depending on whether you're traveling for business, working from home, compensability can be quite different. Okay, so that concludes the COVID portion of our presentation, but I just want to point out that Chartwell does have a COVID resource center where we are constantly posting articles, blogs, videos about COVID in the various jurisdictions in which we practice all over the East Coast. And the link to that is www.chartwelllaw.com/COVID-19. So please be looking for that if you're interested in getting more information. And we also have a couple of links here to other articles that our attorneys have written. Actually, that article assessing the New York's workers' compensation COVID-19 coronavirus claim was written by Lauren herself. It's a very in-depth and detailed article, and I just briefly summarized some of the points from there. But if you'd like to see more details, then I certainly encourage you to review Lauren's article, which you could send to you or you can access through this presentation. Now, to update everyone on some other third department case law developments, which we think will be very influential. Lauren mentioned earlier the Jacoby Medical Center case. So the holding in this case was that post-classification temporary total disability benefits do not count toward the caps for PPD benefits. So if someone is classified with a permanent partial disability, but afterwards they have to get a surgery, and after the surgery they are entitled to temporary total disability benefits. Once that entitlement ends, once there is an opinion that they are now only partially disabled, even if it's their so-called temporary disability is higher than their permanent partial disability, the awards revert back to the PPD rate. And the PPD caps are told while the claimant is receiving the temporary total disability benefits, so they do not count against the caps. And there's no more temporary partial benefits either after someone is classified and they have a surgery. It's either temporary total disability or back to the PPD rate. Now, it's important to note here that someone who has been classified with a permanent partial disability can seek reclassification at a different PPD rate based on alleged change of condition. And this can occur anytime, even after the caps expire. So someone's caps may expire, they can be reclassified after the fact at a higher permanent partial disability, higher loss of wage capacity rather, and they can get additional benefits that way. But this is subject to Section 123, which says that a claimant cannot apply for additional indemnity benefits 18 years after an accident and 8 years since the last awards of indemnity benefits were directed. If it's less than 17 years since the accident, or if it has not yet been 8 years since the last awards, then they can get additional awards. But if the 18-8 rule applies, then they're barred from receiving additional awards. And this is to be distinguished from someone who can apply for reclassification to total industrial disability or permanent total disability if they have a loss rating capacity of 75%. In that case, they can apply based on extreme hardship, which is not a medical issue. It's more of a financial hardship. They can apply to be reclassified and receive additional benefits beyond what they were previously entitled to. So something like this will come to an effect. Say you have someone who's been a school bus driver his whole life. He's now 80 years old, was classified with a 50% loss of weight capacity, which is relatively not that high. But because he's 80 years old, he can no longer be retrained in a different profession. It may not be safe for him to drive a school bus any longer because, say it's a neck injury, he can't turn his head anymore. Since he can't be retrained in a different profession, he can't return to work in any capacity, even though he's been classified with only 50% loss rating capacity. And therefore, he can be reclassified with a total industrial disability, and there would be no caps in that case. And this is purely on extreme financial hardship. It has nothing to do with one's medical deterioration. If something like that happened, then there would be a change in condition, and then you reopen the case and you get reclassified. But unlike that, which can occur anytime, subject to Section 123, for a claimant to be reclassified with a total industrial disability, it has to be within a year prior to the scheduled exhaustion of the caps. Once the caps have
to be above 75%.
Right, that's important to mention as well. Once the caps have expired, or if the LWAC, oh, okay, so I apologize, I made a mistake. In my example, a 50% LWAC would not get an 80-year-old school bus driver reclassified. It would have to have been over 75%. So thank you for correcting me, Lauren.
And yeah, I would just note that, like, as far as the TTD benefits post-classification, the boards, the courts are basically treating, if you have a surgery post-classification and you have TT, that's like a temporary exacerbation, and then you go back to your PPD. And then if you want higher awards, you have to show a change in condition, like a change in a worsening of your permanent impairment, which makes sense.
Okay, now obviously you all probably know by now that there's been a huge change in claims where someone can get a scheduled loss of use even though they've been classified with a permanent partial disability. There was that famous Tire case back in 2018, a third department decision that radically changed the law in that regard. In 2020, there were 3 new decisions listed at the bottom of the slide that reaffirmed the Tire decision. So basically now, someone who is working at their pre-injury wages, even though they've been classified with a permanent partial disability, can receive a scheduled loss of use, whereas in the past, they would have only received a scheduled loss of use if there was no permanent impairment to the non-schedulable sites like the neck or back. Now they can get a scheduled loss of use even if there is permanent impairment to the neck or back, so long as they're back at work at pre-injury wages. Now, what if someone still is not at MMI for the neck or back, but they are at MMI for the schedulable sites? The board did not, the decision does not address that. So if someone still has temporary residual impairment to systemic area, such as the head, neck, or back, but they're at MMI for all of their extremities, can they go ahead and receive a scheduled loss of use? the third department has not ruled on that issue, so that still remains to be seen. But it is worth noting that the board is now revisiting old decisions where claimants did not get scheduled loss of use awards because they were classified with a permanent partial disability. And in the case of pro se claimants who are represented, they're actually going back and looking at those cases themselves. In cases where claimants are represented, then their attorneys can request for them to receive scheduled loss of uses. Now that, even though that they may be back at work and their cases closed a long time ago. So be on the lookout for old claims coming back for new scheduled loss of use awards. So oftentimes we will stipulate the schedule loss of use. And now in the past, claimants would have sort of willingly stipulated to not having any permanent parents in or back in order to get schedule loss of use awards. But now that they can have potentially both, stipulations are now a bit different and maybe a bit more difficult to agree on. So for non-scheduled loss of use sites, the stipulation must indicate either that the site is permanently disabled and the loss of wage earning capacity percentage, or a finding that the site is fully resolved with no permanent impairment. So now we sometimes will stipulate, or at least could stipulate, to just schedule loss of use and then still litigate the loss of wage earning capacity. But that is handled differently on a case-by-case basis. And you don't need opinions on the neck or back in terms of what their permanent impairment is, as long as the parties can agree. But obviously, if we don't agree, then that is something that has to be opined by doctors and then potentially litigated. And it's also critical that the stipulation says that the claimant is working pre-injury wages because that has to be there according to the TIRE decision and the 3 decisions that followed this year.
I think we can skip through this quick. The basic gist of this last part is to have IMEs address all established sites when you're getting a permanency opinion, because otherwise the board could address things piecemeal and it'll be messy later on. But if the claimant produces a C43 just commenting on SLU sites and an EC 81.7 just directs you to comment on SLU sites, the board isn't going to award the SLUs without a medical opinion addressing permanency to the non-SLU sites where those are also established. So you might as well just get an opinion on all the sites at once, because it's easier than having to go back for another IME later to address the outstanding sites.
Okay. So if you want to see more information about the EC 81.7 process that is now in effect as a result of these decisions, we have some slides on it. You can reach out to us for questions. In the interest of time, I am going to skip ahead to the other couple of cases that I think are relevant here. Lauren, let's go to the, yeah, exactly. So matter of Green versus Dutchess County BOCES was an interesting decision. The claimant was classified with a permanent partial disability. He died before the caps expired, and then his surviving relatives were awarded the remainder of his PPD benefits, which we think is quite unusual. The third department basically held it would be unfair for there to be disparity between SLU awards, which would go to the claimant right away, and if they pass away, to their relatives, versus someone who is classified for partial disability and is receiving ongoing benefits, and then they die. What happens with the remainder of their indemnity benefits? Well, the third department has decided that it goes to their family as well. We find this to be odd because PPD awards are for cause-related lost time. So and that's why it's paid out on a weekly basis. If someone goes back to work, they no longer receive the benefit. If they're then laid off from their job, they still no longer received indemnity benefits because their lost time would now be unrelated. So a claimant is not just automatically entitled to all of his PPD benefits. He has to remain out of work for cause-related reasons. And if he dies for unrelated reasons, as happened in this case, we find it very strange that the third department would have awarded the claimant's relatives the remainder of his benefits. However, they didn't comment on whether or not this should be paid out in a lump sum or continue to be paid out on a weekly basis. So we're not exactly sure yet how that's going to play out.
And I think this is being appealed further, so hopefully the Court of Appeals addresses it and gives us a final answer on how, whether this would be a big change if unrelated death entitles the beneficiaries to the remaining PPD benefits. So we're monitoring this case and we'll advise of any updates via email blast.
The next case I want to discuss is matter of Ranko versus New York State Police, because this could actually affect how some COVID claims are handled. So here, the claimant was a mechanic that allegedly developed prostate cancer as a result of exposure to toxins. He was working in Albany while cleaning police vehicles in World Trade Center cleanup operations. And this was found to be an occupational disease, even though there's no inherent exposure in the work of a mechanic to these sort of toxins. However, the third department said that the exposure here was not from the work environment, but rather from the work that he was doing. But again, as I said earlier with regard to occupational diseases, they require a recognizable link between the alleged condition and distinctive feature of the work itself. And the work of a mechanic typically does not involve exposure to toxins, and that's why we think this should be an accident and not an occupational disease. Because, for instance, if there's mold in someone's office, then even though you're exposed to it over a period of time, that's not inherent to the employment. That's not inherent. That's not an inherent risk of the job that you're doing, but rather it happens to be a risk of the environment that you are in. And so that actually should be an accident case. And so we think that same logic should have applied here, but the third department decided otherwise. And we think that the claimant's bar might use this case to try to push COVID claims through as occupational disease cases. And why is that significant? Because occupational disease cases are easier to establish than accident cases. So first of all, OD cases, claimants have 2 years to file them from the time they knew or should have known about this condition. So there's more time to file the claim, a lot more time for notice as well. You have the 2 years, and also there's a lower burden for causal relationship. You don't have to demonstrate that work definitely caused it, just probably. Because in occupational diseases, you can never know 100%. But with an accident cases, there's a greater degree of specificity that is required to establish these cases. So we think that the claimant's bar might rely on this case to try to characterize COVID claims as occupational disease cases, but as we had discussed earlier, we don't think that is correct.
Yeah, this is like sort of akin to someone who is assigned to a COVID ward in a hospital being found to have an OD for COVID because of their specific assignment at the time, which is what was the case here. He was exposed to toxins from cleaning toxins off cars. That's the analogy I see to COVID cases. If someone's sort of specifically assigned to do something with COVID, then this case could be cited in support of claiming an occupational disease. Yeah, I don't agree with it. It's inconsistent with other third department decisions. But yeah, there's arguments to dispute it case by case. Go ahead.
Okay, and the very last two cases we're going to mention are matter of Hill versus Rochester Cell Phone Corporation and matter of St. Aubin versus the Office of Children and Family Services. So the Hale case was actually helpful for us, as was the latter case. These are favorable decisions to carriers. A claimant is not entitled to additional protracted healing period award after a prior schedule loss of use in the absence of evidence of a change in condition or increased schedule loss of use, regardless of any subsequent surgeries or temporary total awards. So in this case, the claimant had a 55% schedule loss of use with some PHP. After that, she had 2 cause-related surgeries, and then she had some awards at the temporary total disability rate again. And then she tried to claim additional protracted healing period based on those awards. And the third department rejected that application. They basically said that unless you have a new schedule loss of use that is higher than the previous one, you're not entitled to additional awards for protracted healing period, unless there's been a change of condition. Now, you might be wondering how someone who's been at MMI and then has surgeries, how they may not be change of condition. Well, change of condition has to be a formal finding. So oftentimes doctors will file NP2s after someone's already at permanency, and then if a carrier authorizes those, there's no formal finding of change of condition. So therefore, she would not be filed. So therefore, the claimant would not be entitled to additional PHP awards. Alternatively, the surgery could be contemplated before the claimant's ever received her first schedule loss of use award, but for some reason she decided against getting it at the time, and then she went and got it later. It's not like her condition changed, but she just decided to get the surgery. And so again, if there's no change in condition, if there's no increased schedule loss of use, there are no additional awards for protracted healing period. And the very last case is helpful for us as well, because it affirmed that there can be apportionment in the schedule loss of use to a prior injury, even though the prior injury was not a workers' compensation case and was not compensable. But the third department affirmed that had that prior injury been the result of a workers' compensation accident, that would have been compensable. Then it would have resulted in a schedule loss of use. And so we can apportion current schedule loss of use to some of that prior accident. And obviously that's helpful for us as well. So that is our last slide. And we thank all those of you who have stuck with us to the end. If you do have any questions, we can stick around for a bit longer, just post in the Q&A. But otherwise, we thank you for attending. And we appreciate all the time you spent with us this afternoon. If you have any additional questions, please don't hesitate to be in touch with us directly. Thank you so much.
Thank you, everyone.